Hello and welcome to Computology Academy, and today we are going to discuss a very important topic which is related to paper 2 of UPSC Civil Services exam, and that is related to polity. And this is an important topic because time and again this law is in news, and recently yesterday also it was in news because the Union Law Minister Kiran Rijiju was replying on the comments of Supreme Court. So here this section IPC section 124 subsection A, this relates to the sedition law, and this is a colonial era law which is still in existence. So what are the controversies related to it? What are the provisions of this law, and how does it affect the freedom of speech in India, and why many of the organizations, media personals and various other NGOs are against this law? We will discuss in detail here in this video. So watch the video till the end because it will clarify many of the things which is related to this topic, and that will be helpful for you to write the answer in UPSC exam and in other civil services exams also. So this was in news because Kiran Rijiju, the Union Law Minister, stated in the parliament, in his statement in the parliament, he said that no proposal to scrap that sedition charge from the IPC, so the Indian Penal Code 1860, in that there is a section that is 124A, and that relates to sedition charges, and the Indian government is not of the opinion, there is no proposal to scrap it. And we have seen that time and again many governments have changed, many of the prime ministers have changed, and they are talking about scrapping this because this is curtailing the freedom of speech. Time and again they say that when they are in opposition, but when they are in power, none of them had taken any step to scrap this law. And he was replying to the Chief Justice of India N.V. Ramanna's remark in an open court which was made on July 15 this year itself. And there were various petitions filed which we will see in the next slides, that this law should be scrapped, and they had challenged it, and on that ground all the petitions were clubbed together because all of them are based on the same question. So Justice N.V. Ramanna was hearing that petition, and on that he had made various remarks that we will see in the coming slides. And here Justice Ramanna was of the view that the government should clarify its stand on that matter. The Attorney General had answered to the Justice Ramanna's question on government's behalf. So here the petitions against it, many petitions have been filed. Some of the important petitions are here which are clubbed, and those are one filed by Major General S.G. Vambatkar, and he is a retired Major General, he is an army official, and he is also of the view that this section curtails the freedom of speech. Thereafter the Editors Guild of India had also filed, along with the cartoonist Asim Trivedi. He had made a cartoon of the national emblem, and because of that he was arrested and the sedition charges were implemented on him. Thereafter Kishore Chandra Wangkheme, he had also filed one petition against the sedition charges laws. And thereafter Amoda Broadcasting Company Private Limited, this is a broadcasting company which runs a news channel in Andhra Pradesh, and they had also filed a petition in the Andhra Pradesh High Court, and thereafter they moved to the Supreme Court. And thereafter senior journalists Arun Sori, along with his NGO Common Cause, had also filed one petition, and all these petitions have been clubbed together by the Supreme Court to be heard simultaneously and collectively. So what were the observations, what were the remarks of Chief Justice of India? So the Chief Justice of India made various chilling remarks on this law. One of his important remarks was that it is a stale law. What does stale means? The stale means that any of the food or something that were prepared too much earlier and that they are not good to consume at right time, and because of that it should be thrown away, it should be scrapped. So same is the opinion of the Chief Justice of India about this sedition laws. He is of the view that these laws are spoiled, these laws are stale, and they are of no utility in the present day time, so these laws should be scrapped. And he was of the opinion that many of the stale laws have already been scrapped by the government of India from the statute book. So the government of India should take the initiative to to scrap this sedition law also, because it is curtailing the freedom of speech and expression of citizens of India. Thereafter, he was also of the view that there is very low conviction rate regarding the sedition laws. All those people who are booked under the sedition law of section 124A are not convicted at all the times, because many of the sedition charges which are framed against the accused people are not appropriate, are not supported with adequate evidence, and because of which what happens, they are not convicted, and it only wastes the time of the court, as well as it also curtails the freedom of speech because of the fear of getting accused of these laws. And he was also of the opinion that there is misuse of power by the executive, because many of the times the executive book any journalist or any person who is criticizing the administrative work of the government or the laws which are being passed by the parliament or any other thing, and those are constructive criticism, but due to the unacceptability by the administration or the executives, they are slapped with the sedition charges. And because of this, CJI was of the opinion that it is being misused by the executive against the citizens of India, and ultimately these laws, these administrative works, all of them are for the citizen of India, so they should be having the freedom of speech and expression to criticize the acts and deeds of the executives and the legislature constructively. And because of this, he was of the view that these sedition laws should be scrapped. Again, he gave an example of a carpenter, that a carpenter was provided with a tool to cut down the wood, but what happened? The carpenter used the same tool to cut down the whole forest. So was it a constructive thing or was it a destructive thing? Same is the opinion of CJI, Chief Justice of India, that the sedition charges, the seditious laws were incorporated to curtail the criticism of the colonial rule. However, in the sense of India, it should be used only when there is any clear-cut threat to the security and integrity of India, but not on the will of the executives only. This was the opinion of the Chief Justice of India. And thereafter, come to the IPC section 124A. What does it says? Because all the criticism we have heard, all the arguments we have heard, what is the current situation, why it is in news, but we should know about the section, know about the details of this law. So here the law says that whoever by word, either spoken or written, or by sign like the cartoons, symbols, etc., or visual representation like those videos or other things, or otherwise by any other means possible, brings or attempts to bring, like causes or tries to cause hatred, contempt, or excites or attempts to excite disaffection towards the government, disaffection towards the government or disloyalty, whatever you say, the government established by law in India. At that very time it was said government established by law, because what kind of government will be in India, that was decided by the British Parliament and by the Crown's advice and her signature. So here he will be punished with imprisonment for life. Like, see here, what is the atrocity in this section? Life imprisonment is there as a punishment, and thereafter to which fine may also be added, or with imprisonment which may extend up to 3 years, to which fine may be added, or for with only fine. So this was the complete provision. Here there were clarifications also for the words like expression, etc. And let us see the explanation of the expression. So here the expression means disaffection, includes disloyalty and the feeling of enmity towards the government or the government officials, because to rule India the British government needed to secure the security and the life of the officials who were running the government here, as well as the government as a whole. So because of that they were of this opinion. But here the comment says, the second comment says that expression, that is expressing the disapprobation of the measures of the government with a view of obtaining their alteration by lawful means, without exciting or attempting to excite hatred, contempt or disaffection, do not constitute an offense under this section. So here clear cut protection have been provided for the constructive criticism of the government, right? It was included during the British time itself. But here when the government is elected by Indian citizens itself, these protections are not being followed, these provisions are not being implemented in letter and spirit, and that is a matter of concern, because of which that carpenter example was provided by Chief Justice of India. And here if the executives, the law enforcement agencies will be provided with the proper training of how to use this law, and if it will be used constructively, then it may be beneficial for the security and integrity of India. But time and again it is being misused, and because of that there are voices to scrap this law. And again if we see the next comment, then it will make it more clear that the comment expressing the disapprobation, like any of the comment, signs, visuals, etc., whatever is there, disapprobation of administrative or other actions, like if there is any administrative failure, like if there is mismanagement of any disaster, any construction work is not being done properly with the adequate quality control, and if it is being criticized, so here what will happen, this will also not be considered as seditious if it is done without exciting or attempting to excite hatred, contempt or disaffection towards the government or its officials. So it will not be an offense. So here again there is a protection provided to the citizen of India under this law, but these things are not being followed, and that is being the matter of concern here while using the sedition charges against any citizen of India. The constructive criticisms are not being welcomed by the executives, and because of that there are voices being raised to scrap the sedition charges or the laws related to sedition. Now come to the history of development of this section 124A. as we see time and again in the news that it is a colonial era law, it should be scrapped and all those things. So how does it came into existence, and what was the history of its development? So initially it was proposed in the draft penal code of 1837. At that very time it was proposed to be incorporated under section 113, but later on this was not included in the finally implemented penal code, because even the British government was of the view that this may not be of so much use at that very time. Thereafter, it was also not included in the Indian Penal Code of 1860 that was suggested by Macaulay. Here also it was not included. But later on, after the Wahhabi movement, it was added in 1870 through an amendment that was suggested by James Fitzjames Stephen. He was the person who had suggested the inclusion of section 124A and the sedition charges, sections related to sedition, in the IPC in 1870. And this was mainly done to handle the legal issues that were coming in front of the colonial government of India, and these issues were related to the Wahhabi movement and its related activities. And mainly during the Wahhabi movement period, what was happening, whenever there was any gathering at the mosques or any religious gathering, then the Muslim preachers used to preach the hatred, used to excite the people, excite the dissatisfaction against the British government, and to handle these gatherings, to handle these Maulanas, these preachers, mainly this section 124A, that is related to sedition charges, was introduced in IPC in 1870. Before that there was no such kind of law in the IPC itself, and there were many victims after the introduction of these sections in IPC, and some of the major victims of this section were Bal Gangadhar Tilak and Mahatma Gandhi, who were imprisonment after charged under these sections. And here amendment were made to a large extent in this section through the Amendment Act of 1898 here in the IPC, and these amendments were made basically to handle the situation which were arising out of the activities of Congress, out of the activities of Bal Gangadhar Tilak and many other revolutionary and extremist activities. Now come to the independent India. Here in the independent India in 1958, Ram Nandan versus state. Here this case was filed against the state regarding these sedition sections in the Allahabad High Court, where the Allahabad High Court had declared these sections, these laws as void. The Allahabad High Court was of the opinion that in free India there should be freedom of speech and expression as it is provided in the constitution, and because of that these sections are unconstitutional. And the same was the opinion of Punjab High Court, and the Punjab High Court had also struck down these sections from the IPC. But these judgments were challenged by the government in the Supreme Court, and here in the Supreme Court judgment in 1962, it brought back the sedition charges into existence, interpreting that the sections were applied only if there is incitement of violence. Incitement, if there is any incitement of violence, only then these are being implemented and these are being charged against any of the person who is accused. And Supreme Court was of this opinion because of the second two comments, in which the expression was defined, where if there is no incitement of excitement and lawful means are being used, and they are criticizing the administrative and the executive activities to brought about plausible changes through lawful means, then these charges cannot be implemented or cannot be imposed on any person. So this was the opinion of the Supreme Court, and because of this the Supreme Court upheld the constitutionality of section 124A in 1962. But the government is not following all these things as it is provided in the section 124A itself. And we should not say the government, but basically the executives are not so proficient to use it on case to case basis. Wherever they think that we can use it, they use it. They are not giving it a proper overlook how to use it, where to use it, what are the lawful means, what are the unlawful means, where is constructive criticism, where is incitement of disaffection and disloyalty to the nation. So these trainings would be provided to the executive before using these sedition charges against any person in India, because India is a democratic country and we have to uphold the freedom of speech and expression for the constructive development and functioning of the democratic values. And here, last but not the least, I would like to inform you all that the General Studies Foundation course has been announced by the Polity Academy, and here the foundation course is for 2023 batch. So those students who are willing to appear in the UPSC IS exam 2023 can join this batch. This is a pre-cum mains exhaustive batch in which the holistic coverage of the syllabus will be there, regular tests will be there, and proper tracking of the improvement of the students will also be there. And this is offline course which will start from 3rd of January on 8 AM. And here the students should register as soon as possible, because the seats are getting filled up quite fast, and after the 40 seats will be exhausted, there will be no admission. So reserve your seat as soon as possible, and for that matter you may contact us on our landline number. You can also get in touch with us on our WhatsApp and the mobile number, or if you want to do it by your own, then go on to our website, that is www.computology.com, and you can register for the course directly from there itself. And here you may also follow us on our Facebook and Instagram channel. This is our Telegram channel, and do subscribe our channel and press the bell icon to get notified whenever we upload new videos. Thank you very much and have a nice day.